I would now like to introduce our presenter today, Wayne Rose. Mr. Rose graduated from Robson Hall Law School in 1984. After articles at Legal Aid, he was called to the bar in June 1985. Since then, he has practiced primarily in the area of family law as a member of the private bar. He is currently a sole practitioner. He has been active in the Bar Association, serving on the executive and as chair of the family section. He has presented on family law and other topics through the Bar Association, Law Society, and CLIA. We are so pleased to have him here today, sharing his time and expertise with us. And without any further ado, I will pass it over to you, Mr. Rose.
Thank you. So I just want to perhaps emphasize one thing that Nina mentioned, which is that I'm here to give information, not advice. So if you want specific information or advice about your situation, you need to seek other means. As you've heard, I've been at this for a while, and one of the subtexts of this presentation is going to be that the more things change, sometimes the more they stay the same. And what has definitely not changed over the years that I've been practicing, and I don't think probably ever will, is that what we call move-away cases or situations where one parent wants to move or has moved and the other is remaining are very difficult cases. They're difficult questions for judges. They're difficult for lawyers to handle. And it goes without saying, but let's say they're very difficult situations for the parents involved on both sides. When somebody wants to leave town, leave the province, sometimes even leave the country, certainly within Canada they can. Our Charter of Rights and Freedoms enshrines mobility rights. However, our courts retain a jurisdiction over the children of separation, and they have to make some choices very often between the parents as to how this move is going to affect everyone and what, if any, changes need to be made in the arrangements that may be in place. Unlike most issues in family law, this is not a situation or a question that lends itself to compromise. It's pretty much an either-or situation. Either the parent moves with the child or the children, or they don't. And as a result of that, it's one of the more heavily litigated areas. And it's something that very often ends up in trials, unlike most family cases, which generally find a way to settle. The courts have struggled with these decisions for many, many years. They've had limited direction from the legislature until recently, and I'll talk about that a little bit more, quite a bit more as we go along. We're looking at a number of issues. We have a very mobile society. People move around. Sometimes they have to, sometimes they want to, sometimes they have great reasons, sometimes the reasons may not be quite so compelling, but they move. They move provinces, they move cities, and as I say, sometimes they move countries. The second issue that complicates matters is that within separated families, what we've seen over the years, certainly over the time I've been practicing, is that these families, even though separated, they've become increasingly integrated. And what I mean by that is there's still lots of interaction. The days when dad would see the kids on alternate weekends and not otherwise are pretty much gone. There's a lot of shared time. There's a lot of parents that have a lot of investment and activity with their children on both sides of the separation line. And that, of course, makes it more difficult to make these decisions about who should move and who should stay, and whether the children should go one way or the other. The courts start with a basic premise. The basic premise is that we should do what is in the best interests of children. The late Justice Bowman used to say to people, I don't care about you. I'm here to look after the kids. That's a somewhat direct way of saying it, but that really is the guiding principle. That being said, best interest is a pretty ambiguous statement. And the reality is that when people come before the court, with rare exceptions, both parents think that what they want or what they're proposing is what's best for their children and in those children's best interests. And it comes to the court, or it falls to the court, to try and sort through everything and decide what is in fact in those children's best interests. We've had some guidance over the years, over and above the legislation. And as I say, that until fairly recently, best interest was pretty much the guidance we had from the legislation. There wasn't a lot of specificity. We had the Supreme Court weigh in a number of years ago in a case called Gordon and Getz, a case where a woman wanted to move with her child to New Zealand, if I remember correctly. And what the court did in that case was they said, first of all, we're not operating on any kind of presumptions. We don't start from a starting point. We start from, again, what's best for the child. And then it laid out a series of considerations in these cases. And those considerations have been used, have been abused, have been added to and considered over the many years since. The other thing that has impacted on this issue is a growing concern about and recognition of the impact of violence where it exists. Familial violence, we now understand, isn't just a question of stopping the hitting, as it were. It's a question of how it affects people, how it affects the victim, how it indeed affects the perpetrator, and to a very great extent, how it affects children. And children don't necessarily have to be the victims of violence to be infected or to be affected by violence in their home. And we know that they very often are, and that's an issue that needs to be addressed in these situations. There are a lot of special issues that arise when talking about move-away cases. A few basic things to remember are that when we're talking about how we deal with these cases from a point of view of what law is applied, we're talking about two separate jurisdictions, and they're concurrent. That is to say, they operate at the same time. There's a federal jurisdiction because the feds are in charge of divorce and related issues, and questions concerning children are considered related to divorce and to decisions around divorce. But the province also has an interest and also has legislative authority in this area. Very often, both provincial legislation and federal legislation are pled and considered. Certainly, however, the province also, provincial legislation is also important. We're talking about people who may never have been married and may therefore not come under the divorce act. There's one final issue that comes up with move-away cases and that makes them complicated and difficult, and that is the timing of the whole thing. Typically, people don't come to court and say, I'm going to move in 5 years. They come to court and say, I've got a new job and it starts in 3 months. Or I've sold my house and I want to move sometimes next week or whatever. Courts don't move that fast as a general rule, and that is frequently a problem in these situations. Which is not to say that no one is trying to come up with solutions, and that's what we're here to talk about today. Governments have turned their minds to this problem. Both the federal and provincial governments have turned their minds to this problem, and starting in the early 20s, 2021 and 2022, they've made changes. Federal Parliament made changes to the Divorce Act, and our provincial legislature made changes to our act. In fact, developed a whole new act and a much more comprehensive act than they had before, which includes addressing these issues. And it's now called the Family Law Act. It used to be called the Family Maintenance Act. Now it's the Family Law Act. And one of the things they did in the Family Law Act is they made the provisions around parenting and decision-making about parenting, they made those provisions consistent with what is now in the Divorce Act. There were some differences and discrepancies previously, Now they're pretty consistent. You can basically follow one or the other. You're going to come up with the same provisions. One of the things that has been done is that they have ordered or required that a parent that is moving must provide notice to the other parent. And there's a distinction made here. If you're simply changing residence, so if you're moving from St. Vital to St. Boniface, you have to tell the other parent where you're going, when you're going, give them contact information, and so on. That eliminates, and it may sound strange, but the occasions where people would call us up and say, my spouse or my ex-spouse comes to pick up the children every week, but he won't tell me where he's taking them. This makes it clear, and it's legislated now, that that's simply not okay. That's not on. More to the point, given today's discussions, it's also provided a specific protocol for what you do when you want to move. And what you do under the legislation is you provide not less than 60 days notice to the other parent. And there are specified forms, which you can find in the regulations to the Divorce Act, to fill out, and which say, here's the information you need to provide to the other parent, and you need to do it 60 days before any proposed move. There is also a form, and there is also a provision in the legislation that says that if the other parent doesn't agree with the move, they have to notify the moving or the proposed moving parent within 30 days of that notice that they are opposed to what's going on, at which point it becomes a matter for courts to decide if parties can't work that out. There are provisions in the legislation for a judge to waive notice and notice periods. The most common times where they might do that are where there's been extensive or ongoing violence or harassment or negative behavior. The second would be where a parent has simply disappeared, dropped off the face of the earth, so to speak, and nobody knows where they are. So in those kinds of situations, the legislature has provided that a judge can waive the requirement for notice. Now, people can't just pick up and leave. It happens. And I'm going to talk about that a little bit more as we go through and as we talk about some of the specifics of the court proceedings that are involved here. If the matter is opposed, the legislation also says to us, here is who bears the burden of proof. That is to say, who has to convince the judge that their position is right. In reality, of course, both parents do, but we start from certain positions. If the parties have had what is called substantially equal time, that is, the children have been spending substantially equal time with both parents, then the person who wants to move starts with the burden of showing the court why this move is in the children's best interest. If the vast majority of the time has been spent with the moving parent, that is to say, the moving parent has been what we used to call the primary caregiver, the person who mostly looks after the children, then it is up to the person opposing the move to convince the judge that it shouldn't. And the legislation goes on to say that if neither of those conditions applies, basically then it's up to both parties to convince the court where they're coming from. The legislation sets out specific factors that the court and the parties should consider. And it goes back in a sense because the legislation provides specific factors to consider in any decision concerning children. It provides further factors to consider where there has been family violence. And then finally, there's a new set of factors to consider in a move-away case. And it's fair to say that in a move-away case, you need to look at all three of those sets of factors, and they're all laid out in the legislation, basically a list of factors for each one. And I'm going to go through them. I'm going to try not to bore you too much, but I'll go through them and talk about maybe a few comments about what they mean and how they work. I do want to say, as a preliminary point, this is not a scorekeeping exercise. If there are 30 factors, Dad doesn't get to say, well, the judge agreed with me on 16 of them, so I win. The word you will hear around the courts these days a lot is context and weight. So not every factor is going to have the same weight in every context. Some of them may be more important in one situation than they are in another. That is one of the considerations that a judge has to deal with when they're trying to deal with these situations and these questions. So let's start with factors to be considered generally when the court is looking at the best interests of the child. We start with the child's needs, given their age, their stage of development, and their needs for stability. Sorry about that. I'll turn that off in a second. The second thing is the relationship of the child with each spouse, with their siblings, and with other people that may be important to the child, such as extended family, friends, and so on. Each spouse's willingness to support the development and maintenance of the child's relationship with the other spouse. This is what we call the friendly spouse test. Are you supporting the relationship of the other spouse? Or is it constantly a battle for them to see the child or to have a relationship with the child? And if it's going to be a battle when you're both in the same city, of course, it's going to be worse when you're in different cities, and that's a consideration. The history of care of the child, who has in fact looked after the child. The child's views and preferences, and the weight to be given to them given their age and maturity. So, the views of a 4-year-old may not be given a whole lot of weight. The views of a 15 or 16-year-old are going to be given a lot more weight, especially if that 15 or 16-year-old is saying, I'm not going and you can't make me, sort of thing. The child's cultural, linguistic, religious, and spiritual upbringing, including Indigenous upbringing and heritage. Any plans for the child's care? How is this child going to be looked after if there's no longer a second parent to do so? The ability and willingness of each person in respect of whom the order would apply to care for and meet the needs of the child. And that's an important one and something that is sometimes overlooked. Can this person, in fact, meet the needs of this child? Do they have that ability? Do they have the capacity? Any family violence and its impact. We'll talk about that a bit more in a minute. And any civil or criminal proceeding, order, or condition or measure relevant to safety and security of the child. So are there child protection proceedings going on? Are there criminal proceedings going on in which the child may be a complainant or a protected party? So those are our starting points, considering how and what kind of orders we're going to make concerning children. If there is family violence, the court has to consider that and it has to consider its impact. So you have to look at things like the nature, seriousness, and frequency of violence, and when did it occur? Was it an isolated incident 10 years ago, or is it an ongoing problem? Is it occasional stupid verbal abuse, or is it somebody actually assaulting the other party? Is there a pattern of coercive and controlling behavior, which doesn't necessarily have to mean physical assault, but there's other ways of coercing people and enforcing their behavior. Whether the family violence is directed toward the child, or whether the child is directly or indirectly exposed to it. The physical, emotional, and psychological harm or risk of harm to the child. Any compromise to the safety of the child or other family members. Whether it causes the child or other family members to fear for their safety. Any steps taken by the alleged perpetrator or the perpetrator to prevent further violence? Are they in counseling? Are they taking programs? Things like that. And then a catch-all, any other relevant factor. Now, it's not specified in the legislation, but I think it's fair to say that there's another factor when it comes to family violence, and that is, quite frankly, how strong is the proof? Because family violence is often denied. So it becomes a question for the judge as to how much and to what extent does the judge accept the allegations or the claims of family violence. Finally, we have our third set of factors, and that is having to do specifically relocation. So, number one, the reason for the relocation. You know, it's a good deal stronger if the relocating or proposed relocating party comes to court and says, I have a great job, I'm making, you know, six figures, and they've transferred me to Vancouver, and if I don't go, I'm going to lose my employment. That's a pretty strong case for a move, as opposed to the person who comes to court and basically says, you know, I think I'd really rather live in St. John's, so I'm going. I hear it's a nice place. The impact of the relocation on the child. What is the child going to lose or gain from this move? Or from the move of the other parent, if the other parent is the one that ends up going. Besides the relationship itself, of course. The amount of time spent with the child by each person who has parenting time, whether the person who intends to relocate complied with any applicable notice requirements. Sorry, I've lost my spot for a second. The existence of any order, arbitral award, or agreement that specifies the geographic area in which the child is to reside. And that's something that people put their minds to when they're settling cases. So we will do settlement agreements or court orders, final orders to wrap up a case that will say the child is not to be removed from the province of Manitoba, or their residence is not to be removed outside the perimeter road, or no more than a half hour away from Winnipeg, or whatever the case may be. So if there's something like that in place, that's something to be considered. The reasonableness of the proposal of the person who intends to relocate for the parenting time decision-making responsibility of the other parent. And whether each person who has a parenting plan or decision-making responsibility excuse me, has complied with their obligations under family law legislation in the past. So has someone kept the child when they weren't supposed to? Have they taken off with them? Are they consistently late? Exchanging, things like that. So those are the factors that a court is directed to consider. As I said, it's not simply a scorekeeping exercise. It's a question of considering what weight do we put on these different factors? How important are they to this family and to this child or to these children? One of the things that's coming out of some of the early court decisions, and this legislation is in court terms new. Courts tend to move fairly slowly on these things. But one of the things that's coming out of the decisions that have been made so far is that by and large, the courts are saying this is a codification of the kinds of things we've already been doing, kinds of things we've already been thinking about and applying in these situations. So it's not like we're starting the world over again or we're starting a whole new regime. The other thing, and this is just a realistic consideration, these kinds of lists and these kinds of considerations and factor to consider, the practical effect is that it leaves a huge area of discretion to the judge who's hearing the case, because that judge is going to decide what factors are important. That judge is going to decide in considering those factors which side or which proposal they come down upon. These are still judge-made decisions and realistically are going to continue to do so. So there's a legitimate question to ask as to whether this represents a real change. I would suggest not a huge change, but it does make everyone hopefully better informed. It gives a notice of the kinds of things that they need to think about when they're approaching these matters, checklists, if you like. And it sets out some procedures which hopefully are followed. If they're not followed, as you heard me say a few minutes ago, that is a factor for the court to consider in deciding the ultimate issue. In practice, and that's what we're going to talk about for a few minutes now, in practice, you're probably going to need an order in these situations. As I said, unless the parties can work it out, these are pretty hard things to compromise on and work out, but sometimes they are. But if you don't work it out yourselves, if you don't work it out between counsel, then you're going to go to court and you're going to want an order. There may be an initial order. That is to say, this may be the first time the parties have been to court to get a court order, or there may be this variation or a change to an existing court order. The same considerations apply in either case. That courts seem to be saying pretty consistently, and that's how the legislation reads. Many times, as I said a few minutes ago, you're in a hurry. You want something done right away, and that's generally hard in court. Courts don't move quickly. They don't hear cases quickly. Unlike what you see when you watch lawyer shows on TV, you don't get into court within days of having your problem. I would say, to be frank, in Manitoba, that's a particular problem because the courts have virtually eliminated what we call interim or in the meantime orders. It's very hard to get an order without ending up going the full route and ending up in some form of trial. And that typically is an 18-month to 2-year process, if not more. There is an exception, however, to that. There is an exception in what the court calls emergent motions. And that is a special provision in the family court rules, which says that in certain specific instances, or certain specific circumstances, the courts can kind of throw out the rules, throw out the processes, and let you into court right away to deal with a matter that's emergent, something that's urgent or an emergency. There are 3 criteria. One of them doesn't apply because it has to do with property. The other criteria are where there's a risk of harm to one of the parties or to a child. And there may certainly be situations where a unilateral move or a move of the child would be harmful or could be harmful to the child. The second is where there is a removal from Manitoba, or there's a risk of removal from Manitoba. It's interesting that that talks about Manitoba. Realistically, we're a big province geographically, and a move from Winnipeg to Thompson is hardly less regime changing than one from Winnipeg to Regina or Saskatoon, but that's what the rule says. It's from Manitoba. So I said I'd talk about this. Let me talk about it now. What do you do in the situation where one of the parents picks the child up and skips town, just leaves without any permission, without any notice, and so on and so forth? There are provisions in the criminal code. They're very seldom used, but they are there, that would allow criminal charges to be laid against a parent who, either in defiance of a court order or in defiance of a regime that's in place as between parents, even though they may have come up with it themselves and it may be not sanctioned by court order. If they're breaching that kind of arrangement, there can be criminal charges laid. They have to be approved by the Justice Department, the Attorney General. The advantage of the criminal charges is that they can result in the issuance of a cross-Canada warrant, that is to say, a warrant that's good anywhere in Canada for the arrest of the absconding parent. The other option, again, would be to bring a matter before the court, bring it quickly on an emergent basis, ask the court for an order, and having an order in place, and typically that order is going to basically say, bring the child back here and submit yourself to the jurisdiction of the court and to the decision-making of the court. And then it's a question of sending that order to the other jurisdiction where the child may be and asking them to enforce it. There is a similar process or provision for international matters where someone may have taken off to a different country. It doesn't apply to every country, but there are what are called the Hague Conventions on International Abduction, which also provide for the enforcement of a custodial or parental order directing that a child be returned to the country of origin. They're difficult and expensive, but if you're facing a situation such as that, and provided that the other country is signatory to the Hague Convention, they provide you with a civil way of doing this, and you don't have to engage former commandos from the SAS to go and grab your kid, which actually did happen in a case a number of years ago. In practice, and I'm talking about emergent motions once again, first of all, you have to apply to the court for permission to bring an emergent motion. Secondly, I would suggest in these circumstances, you might actually have to slow the process a bit, because typically emergent motions are heard within days to a week of permission being given. There may be circumstances in a removal case where, especially if both parents are still here and one is just looking to move in the fairly near future, there may be a reason to slow that down a bit and give it a more thorough presentation on behalf of both parents. What you're going to get out of that emergent motion is what we call an interim order, and that's an in the meantime order. Judges and courts being somewhat conservative, small c conservative, in the way they approach these things, in most cases, what you're going to get is an order saying the child should stay here, the child or children should stay here, let's deal with this in the normal course in court. I'm going to suggest that if people are subject to a proceeding for a move away case, either the person who wants to move or the person who wants to oppose the move, there are some things they need to think about, the kinds of things that you need to consider, because this is what's going to ultimately be expected of you, or you're going to want to tell a court. What is very often done in situations like this is that the courts will want some form of an assessment. And by that we mean an independent third party with appropriate training who will meet with the parties, observe the children with the parties. If depending on the age of the children, they may children themselves. They may talk to third parties such as other relatives, teachers, childcare workers, doctors, whoever they've been referred to. And then they will come to court with a report saying, here's what we did. As a result of what we've done, these are our conclusions and these are our recommendations as circumstance. Judges like to have those kinds of assessment reports because it, to some extent, hopefully cuts through the he said, she said of a court proceeding and a court hearing in this situation. Again, the difficulty can be that these assessments, although they are available free through the Family Resolution Services, which is a branch of the provincial government, they take time. They don't happen in a week or so. And if you really are in a hurry, you may have to consider doing a private assessment. And there are assessors who do these on a private for fee basis. It's expensive, but it's usually faster than when you're going to get through the government office. You need to think about what are the advantages for the child of staying or of going? What's their contact going to be like with each parent? And again, it comes back to some extent to the friendly parent principle. It isn't enough, in particular, if you're the moving parent, it isn't enough to simply show up and say, I want to move, it's a good idea, and the other parent can figure it out. You need to, or you want to, show up in court saying, I've got some suggestions, I've got a plan, this is how we're going to continue to keep this person in our child's life. You need to think about other important people, extended family, friends, whoever may be important in this child's life. You need to think about things like programming and education and activities. And in particular, if the child has some particular challenges that are being met by a program here, are they going to be met in the new place? There may be school supports in place. There may be counseling or psychiatric or other services available that are already being used. Are they going to be available in the new location? What's the reason for the move? And as I said a few minutes ago, there are really good reasons for moves, and there are reasons that may not be quite as strong. Needing to work is certainly generally considered a pretty good reason. Not liking the other party and wishing you were as far away from them as possible is clearly not. Hardly anyone ever admits to that, although it's not infrequently a subtext. Moving to be with a new spouse is a reason that comes up quite frequently. How strong is that relationship? What are the circumstances of the new spouse? Are there any reasons to be concerned about that person, and so on? What kind of supports are there in the new location? Family, as I said, educational, programming, and so on. Don't ignore the general principles. I mean, it's easy to focus on here are the factors that the court will consider in a move-away case, but you also have to go back to first principles. Is it proposed that a person who, frankly, does a good track record of looking after the children, or doesn't have much experience of looking after the children, is now going to be caring for them full time? And if they are, do they have a plan? Do they know what they're going to do about childcare and maintaining relationships with the other parent, and so on and so forth? This isn't anywhere in the legislation, but it's a consideration. It's one that courts certainly think about, and that you need to be prepared to talk about and to make a proposal about. And that's what's going to happen to the financial arrangements between the parties. Typically, there's going to be some form of support being paid. If the support payor, or the person who would ordinarily be being paid support because they're not primarily looking after the child, is now going to be facing significant expenses to maintain contact with that child, should they also be expected to pay support? In many cases, they won't be. What's that going to do to the financial circumstances of the move-away parent? What are all of these things going to do to the financial circumstances of the parent who needs to stay in touch? And it may be the move-away parent, it may be the one who stays here, because either of them could end up having their children a long ways away, needing to spend money to maintain that kind of contact. One of the things that the legislation addresses specifically, and this was always going to say a gambit in these cases, the person moving away would inevitably be asked, and what are you going to do if the court says no? In other words, do you move without the children, or do you stay here? it's a double-edged sword, and it's a really unfair question. And that's acknowledged in the legislation, which says we don't consider that. Don't ask the question. If you're involved in one of these situations, you need to have a plan. You need to have a plan for your own caregiving of the child and everything that goes along with that. You need to have a plan for contact with the other parent and how that's going to be managed and arranged and happen and paid for. And you need to consider both options. If the child is with you, what's your plan? If the child is not with you, what's your plan? Because frankly, if you show up in court and the other side has a well thought out plan and all you want to say is, but I don't want it to happen, then more than likely it's the other party that's going to be listened to, and it's the other party that's going to have their plan adopted. Especially if you're the moving party, but in both cases, do some research. What's available in this other location? Again, we come back to things like education, special needs, and if we got a child who's at a high level in some sports, that they're not going to be able to participate in the new location. Do they have special needs that aren't going to be addressed in the new location? Those kinds of things. Have a backup plan. As I said, you don't necessarily go solely on the basis that you're going to win, so you don't need a backup plan. Have that backup plan. A couple of final comments. I've thrown a lot of factors and information at you. If you want to see them in writing, it's fairly easy to do. The legislation is both provincial and federal. The legislation is online. If you go to Divorce Act Canada, that's going to call up the Divorce Act of Canada. You can read the material. It will also tell you where to find the regulations on relocation. And those regulations also contain the forms for notification and expressing opposition to relocation. The Manitoba statutes are all online. You want to go to what are called the CCSMs, and that will give you an alphabetical listing of all the statutes of Manitoba that are in current effect. You go to the Family Law Act, you open it up, and there it is. And it's a very substantial act. So one of the advantages of both provisions or both websites is that they will give you tables of contents so that you may more easily navigate the situation. It's said that hard cases make bad laws, but that doesn't mean we don't deal with the hard cases. Sometimes we don't have any choice. The law, for the most part, in these cases, is made case by case. It's made in context of the people that are standing before the judge. It's made in the context of how their relationship has gone over the years and how it has sundered and how it's gone since that ending. It's made in the context of the children that are before the court, not physically, but their interests are before the court. It's made in the context of the abilities of the parties, of their performance of those abilities, of their connections, and of their relationships. The facts are important. Planning is important. Objective assessments are important. All of these things are part of the package that a person making one of these applications or opposing one of these applications needs to consider, address their minds to. I would suggest get help with. If that's okay, I will open it up. Perhaps, Nina, you can tell me if there are any questions or I've just totally confused everything.
Great. Thank you so much for that presentation. That was a lot of really good information. I know I learned a lot, so hopefully everybody else here did too. We do have a couple of questions that came in, and I received some via email ahead of time as well. So let's just go through those one by one. So somebody is asking, can a parent appeal moving within the city? And I guess more broadly, what is the threshold for when one parent has to provide notice of a relocation to the other parent?
That's a good point, and thank you. I meant to point that out. One of the things in the legislation is that there's an actual definition of what is a relocation, and a relocation is a move that will affect the other parent's relationship with the child. So, if you're moving from St. Boniface to St. Boniface, it's probably not going to be a relocation in quotation marks. If you're moving from Transcona to Headingley, that might be. I don't think that that's been tested yet, but it might be. Certainly, at a minimum, the moving parent has to provide the other parent with notice of their change of residence. And if the other parent thinks that that's enough of a change in circumstance to justify a change in the court order that's in existence or a new court order, then they would have the option of bringing that matter before the court.
Okay, they are asking a follow-up question. I think you've kind of answered it, but if nothing is going to change within the existing parenting arrangement and the kids will still go to school at their current school, is that an issue?
Probably not. Um, if you can maintain the same arrangements, even though they may in some sense be a bit less convenient, uh, we're not worried about convenience. We're worried about actual interruption or impossibility of the arrangements.
Someone asked via email, um, how do judges weigh stability versus opportunity in relocation cases?
You know, the words we keep hearing are holistic. So if we're all being honest here, the judges look at the list, they hear all of the information, and at the end of the day, they decide which is a better plan. So stability is important, yes. Opportunity is important as well. And as I said, it's a bit of an art. Hopefully, we have judges who are artists when we come before them on these cases. That there is no simple answer to it because it's totally contextually determined. It's what's the best decision, what's the best plan for the people who are in front of me on this date with these children.
Mhm. So if you have a situation where maybe somebody is not moving for a job opportunity, but maybe to be with a partner or something similar, then that's sort of less likely to be granted by the court. Is that right?
It's a somewhat harder sell, but it may be there may be all sorts of advantages to go along with that. It may mean that a parent who um, has been going to work every day and leaving the children in childcare, and they may be very young children, is now going to be able to stay home with them. It may mean that there are programs available to some challenged child which are not available. Let's be honest, there are lots of things that aren't available to children. So it really, again, I keep coming back to it, and I don't want to sound like a broken record, but yeah, it's a harder sell, but it's a sell that can be made in the appropriate circumstances.
Okay, and just hearing you say that, that makes me curious. Is it generally easier to sell a move from a rural area than to a major city as opposed to the other way around, just because of the resources that are available and the opportunities for the children as well as the parents?
Yeah, you know, and again, this comes into a balancing thing. I had a case years ago where the party on the other side basically said the child should be moved from the primary care of the mother to him, who's the father, because he now lived in the bucolic paradise of Beausejour, as opposed to the mother who lived in the north end of Winnipeg. No sale on that one. The judge didn't buy that one at all. So there are advantages and disadvantages to any location. Um, if you've got a child who it has really serious needs that can only be met in a major center, yeah, that's going to be a pretty strong argument in favor of that move. Um, but just because Winnipeg has more hockey teams doesn't mean Winnipeg is a better place to live. Winkler may be a very nice place to live. It probably has more hockey teams.
Another question that we have here is, I guess this is not necessarily relocation related, but somebody is asking, is there a plan for a future law to establish 50-50 co-parenting, and would this help prevent people from moving without notice?
I'd say two things on that. First of all, that's been suggested many times, and the legislatures have consistently refused to enact it. And I think wisely so. That's a personal opinion, but I think wisely so. In fact, I can tell you that the state of California many years ago did include such a presumption, and after a few years, they abolished it because it didn't work very well. Would it prevent someone from scooping the kids? No, if anything, it might encourage them to scoop the kids because they think they're not going to win in court.
Another question that we have is the relocation form states relocation with or without a child. If custody is already 50-50, how does that get filled out?
Good question. I don't know. I would say that's going to depend on your plan. If your plan is that we're going to not have 50-50 time sharing anymore, then you're relocating with the child. If your plan is that we're not going to have it anymore, but the child is going to stay where they are, then you're relocating without the child. And you're asking the court now to give consideration to a change in contact arrangements.
Okay, someone says when a parent breaches the family court order, does not return the child at agreed time, or does not pick up at agreed time, who/how should the court order be enforced?
Well, let me tell you how it won't be enforced, and that's by the Winnipeg Police Service. They won't do it. And I can remember many years ago spending 20 years of my life that I'll never get back on the phone with a senior Winnipeg police officer trying to convince him to go and get some kids that were being held contrary to a court order, and I got them. Now the RCMP sometimes take a different view, but if it's sort of a perpetual problem, if it happens once or twice, you got to be realistic. But if it's a perpetual problem, or if it's I've taken the child and I'm not bringing him back, then you need to go to court. You might very well be seeking one of these emergent hearings. You might be seeking an order of contempt against the other person, which is a quasi-criminal proceeding in which the court can punish the person who is ignoring the order.
So we have kind of a compound question here. I'm not sure if this is something that you'd want to comment on, but somebody is asking, is there anything that worries you about these family law reforms? Are there any repeating patterns that you're seeing due to the new family law reforms? Do you see these reforms being weaponized against a parent? And do you have any recommendations to make it better?
I'm going to make a blanket reply, which is not really. As I say, and I think judges are right when they say this, what they've put into the legislation by and large is what judges were mostly moving toward. I think judges that were outliers on those kinds of considerations were probably being successfully appealed. They've put in some notice stuff. They put in some rules. I'm inclined to think that those rules are probably for the best. Certainly, they clarify some things that needed clarification. I don't see them being weaponized. I think no one is saying that there's a presumption. No one is saying that dads win or moms lose or anything of that nature. I think what they're saying is these are hard cases. These are the things we need to think about, but this is how you get there. and don't just take unilateral action. Don't ignore the fact that this child has two parents.
Okay, somebody else is asking. I guess this is a follow-up question to the previous one about providing notice when there's a 50-50 parenting arrangement. They said the plan is to maintain 50-50. What if there's a clause within the current separation agreement stating that notice needs to be provided within 60 days of moving 20 kilometers out of the current city?
Well, first of all, if you provide the notice, then you complied with the agreement. However, that doesn't necessarily answer the question because the move itself may well be a relocation under the Act. And a relocation under the Act permits the court to make a new or different order. And courts aren't always bound by the parties' agreements.
Someone else is saying, I see a couple of people are saying that the presentation was great. Somebody says succinct and easy to follow information and helpful for this community person. Great presentation as usual, Mr. Rose. Thank you. So that's very nice. Thank you for the feedback. We have
Thank you very much. That's very kind.
a couple more questions here. Would it be reasonable to require the moving parent to now do the transportation to and from the city if the relocation is outside the city and normal place of residence and the children's school activities, etc.? Is there any legislation that states this type of requirement?
There's no legislation, but that's certainly the kinds of things that should be considered when you're putting forward your plan. And it's the kind of thing that a judge can order. Just recently, one of the cases that I just read was of a successful application to move the child to Texas. And part of the mother's plan, the moving party's plan, was I will bring the child, or someone will bring the child back to Winnipeg not less than 5 times per year so that they can have contact with the father. That was a successful application, and I think the mother's homework and the mother's very sound plan really carried the day.
Someone is asking about the Hague Convention application. So if one of the parents took the child out of the country, and now the other spouse is looking at the remedy to bring the child back to Canada, do you have a sense of how long these Hague applications take to actually, process?
I don't, to be honest. I think a lot will depend on what other country you're dealing with and what kind of mechanisms they have in place. I've never done one myself. I've seen reported decisions on them. So if you're talking about somebody like the United States or the United Kingdom, you're probably dealing with people that are going to act fairly quickly, always assuming, of course, that they can find the other party and the children. If you're talking about some other countries that may not have the same background or the same development in terms of their legal or court systems, you may be dealing with more in the way of delay. And as I said, if the other country is not a signatory to the Hague Convention, you may have a real problem.
Okay, I think maybe we'll do one more question and then we'll wrap up because we are a couple minutes past 1 here. So somebody is asking generally about false allegations of family violence and what can be done to sort of challenge them, especially if they feel that they haven't had a chance to do so in family court. Is there recourse through the civil court in order to overturn allegations that can be used against them in family court? And they said, in other words, how do we defend something that appears to be undefendable?
Well, I wouldn't say it was undefendable. There's a fair bit of activity in the family division of the court that deals with these very questions. I mean, without getting into a whole lot about special procedures, there's a special procedure to obtain what's called a protection order, and those are routinely challenged. very frequently challenged and lead to hearings. What it boils down to, as it does in any court and in any court procedure, is each party makes their best case before the judge, and the judge decides on what we call a balance of probabilities, which version he or she is inclined to believe. Um, there are appellate processes, but no, you don't get to make a lateral move into the civil division and say the family division got it wrong. Sorry, no, that doesn't happen. Once the Court of King's Bench has made a decision, that's a decision of the Court of King's Bench. You're done, subject to any appeal.
Okay, I think that is all the questions that we have time for today. Thank you so much for taking the time to answer those. Mr. Rose, it was such a pleasure having you present for us today. That was such a well-organized, excellent presentation, and I think everyone got a lot out of it. There are a lot of compliments coming in the chat, which we really, really appreciate. I also want to say thank you to everyone who attended today and for all of your excellent questions. That really helps us sort of narrow down what issues people are having and also what presentations might be helpful for the future. As I said in the intro, there is going to be a very brief survey that's going to come out after the presentation today. So it should come up in your browser window once you exit the Zoom. And there will also be a follow-up email that comes out like 24 hours from now that will have the link to the survey in there. So please do fill that out. Really, really helps us. Once again, thank you so much to Mr. Rose and to everyone who attended. We really appreciate it.
And thank you to Clea for the opportunity and to everyone who's displayed an interest in this. Thank you very much.
Thank you. And I hope everybody has a great day, and we will hopefully see you at our upcoming presentations in the coming weeks.
Bye now.